Please don't leave anything behind, because when the event staff come through and fix the place settings, they will take things away. They will remove them. So, ladies and gentlemen, one other administrative announcement before I do some introductions. Could anyone, and I suspect it's many of you, who have mobile phones, please ensure that they are now switched off or switched to silent. Thank you. Ladies and gentlemen, it gives me great pleasure to welcome you all to the final hearing in this, the 25th annual Willem CB's International Commercial Arbitration Moot. We have seen hundreds of performances by teams across the week, culminating in this particular moment. But teams, excellent performances by so many teams. Today, we have a hearing between the University of Cambridge as claimant and the National Research University Higher School of Economics, Moscow, as respondent. We have for you a stellar arbitral panel. Now, any little introduction I could give would not do them justice. So I would invite you to read their profiles in the Moot book, but I'll also invite them to each introduce themselves as the hearing begins. So ladies and gentlemen, without any further ado, I will step down and hand over to our presiding arbitrator.
Thank you, Chris. My name is Yas Banifatimi. I'm a partner at German & Sterling based in Paris. I head the international law practice at the firm, and I'm also a vice president at the ICC Court of International Arbitration. And I hand over to my colleague.
My name is George Berman, professor at Columbia Law School and director of its Center for International Commercial and Investment Arbitration.
My name is Peter Huber. I am professor of private international law at the University of Mainz. I've been associated with the Moot now for more than 14 years, also helping getting on the nerves of the Mainz team, but we're not intending to get on anyone's nerves today, so wish you a good hearing.
It is a great pleasure and a privilege to be here today, so we will start without further ado. I will ask the teams to introduce themselves briefly, and I will then please maybe claim first.
My name is Barnaby Lowe. I'm representing the claimant and I'll be speaking on the procedural matters. My co-counsel is Mr. Ian Cooper and he will be speaking on the merits of the case.
My name is Gaina Gulan. I will present respondent's position on procedure, and my co-counsel, Mr. Vladimir Costa, will present respondent on merits.
I want to mention that the tribunal, so this oral here today, we will hear only the questions that were set out in procedural order number 1. You are aware of that. So these are questions 1A, B, C, and D. And I want to draw attention to the fact that under sub-question D, we only expect you to address the question of guarantee and best efforts, and not the question of termination, validity of determination. Right? And my last question is whether you have an agreement on the allocation of time.
Indeed, we have agreed that we each allocate 14 minutes for main pleadings and 1 minute for rebuttal and surrebuttal. As regards the order of the proceedings, respondent will start with arguments and procedure, followed by claimant, rebuttal, surrebuttal. Then claimant will start on merits, followed by respondent, rebuttal, surrebuttal.
There's an agreement on that. Thank you very much. We would like to hear you in the rebuttal session. So we will give some measure of flexibility, which would be 14 for main argument and up to 3 minutes for rebuttal. You can keep that in mind. We will try to be generous where we can. Of course, we want to hear out all of your claims and defenses, but we do want to hear you in rebuttals. If you're ready to start, please go ahead.
Members of the tribunal, arbitration is rested in confidence and trust, vested by the parties in their arbitral tribunal. However, in the present case, Respondents' trust in the integrity of the current proceedings has been undermined due to the connections existing between claimant's appointee arbitrator, Mr. Prasad, and claimant's third-party funder. In order to ensure the integrity of the current arbitration, our client is seeking the following two procedural findings. First, that Mr. Prasad's challenge has to be decided by this arbitral tribunal without Mr. Prasad's participation. And second, that there are circumstances creating justifiable doubts as to Mr. Prasad's independence and impartiality, and therefore he has to be removed. And I will start with the challenge procedure. We have 2 points to address here. First, the parties have deviated from Article 13, Clause 4 of the Ancestral Arbitration Rules, providing for appointing authority mechanism for challenges. And second, this tribunal instead has authority to decide on Mr. Prasad's challenge without his participation. As for the first point, it brings us to the interpretation of parties' arbitration agreement located on page 12 of the record. Here, in clause 20, line 3, it reads that the arbitration has to be settled in accordance with the ancestral arbitration rules without the involvement of any arbitral institution and excluding the application of ancestral rules on transparency. In our submission, this reference to the exclusion of institutional involvement was meant to also exclude the appointing authority mechanism, and claimant should have known about this as any other reasonable person in claimant's shoes would have. To start with, this arbitration agreement is ancestral model arbitration clause, with 2 important modifications made by the parties. First, we inserted the wording without the involvement of any arbitral institution and excluded the ancestral rules and transparency. And second, in subsection A, we deleted any mention about the appointing authority that is present in ancestral model clause and is not present in our arbitration agreement.
Counsel,
Yes.
if I may interpose a question here. When I read the arbitration agreement and read other portions of the record, it seemed to me that what you had agreed on was ad hoc arbitration only, and you had not agreed on anything more than that. Can you tell me why I should understand the arbitration agreement differently?
Of course, Mr. Arbitrator. Our arbitration agreement, by the consent of the parties, was subjected to the CISG. And in Article 8, it reads that the one interpretation, the primary consideration has to be the intent of the parties. And to show you what was the intent of the parties, I invite this tribunal at page 41 of the record, where is located respondent's employee's witness statement. And before I cite, here respondent told claimant that it had negative experiences in the past with institutions. And here in paragraph 3, from the bottom of the page, second line from the bottom of that paragraph, why respondent had negative experiences? Because information about the unjustified allegation was leaked by the wife of the competitor's COO who worked for the arbitral institution where respondent had initiated the case, end of quote. Therefore, the intent was broader than just to have an ad hoc arbitration, but was also meant to exclude any staff's involvement, and it was clearly communicated to claimant. And therefore, the parties thereby excluded Article 13, Clause 4 as the provision of ancestral arbitration rules leading to institutional involvement. And I will now show you how it leads to institutional involvement. In line with Article 6 and 13, Clause 4 of the ancestral arbitration rules, the appointing authority is designated by the parties subject to their agreement. And in the present case, the parties have excluded the appointing authority to be an institution, and the only option for claimant to argue here today would be to have an individual as appointing authority. However, for this to happen, there has to be an agreement by the parties, and there has been none during the last 8 months, and it is unlikely that the parties in the present arbitration will reach a consensus. Which means that under the circumstances of the present case, and in line with Article 6 of the ancestral arbitration rules, the matter will eventually go to the Secretary General of the Permanent Court of Arbitration.
I have a follow-up question, if I may. In the prior experience that is being had, the leak that occurred was a leak that pertained to the merits of the dispute. Is that correct? Am I correct in understanding that?
Yes.
And is there no difference between that and the kind of leak you would anticipate were there to be a leak if we were concerned only with a challenge and an appointment?
No, Mr. Arbitrator, there will be also a threat, because as follows from official website of the Permanent Court of Arbitration, any request sent to the Secretary General of the Permanent Court of Arbitration has to be accompanied by the notice of arbitration and response to the notice of arbitration, which means that the institution will get hold of this sensitive information. And members of the tribunal.
I could have a follow-up question. The Secretary General is not the institution itself. That doesn't mean that the PCA, for example, would be acting as an institution. So why is it not a possibility for the parties to reach out to the Secretary General in his capacity as appointing authority and act on his own?
Madam Arbitrator, first of all, in our submission, the Secretary General will be acting in his institutional capacity as representing his office. And any request for challenges has to be sent not to the personal email of the Secretary General, but to a general common leak of the Permanent Court of Arbitration, which means that he is not acting as individual, but he is representing an institution. And while discharging his duty, he will rely on an institutional staff to assist him with the challenge process, which means that Article 13, Clause 4 is an open door for institutional involvement and thus was excluded by the parties. And in line with Article 1, the parties thereby modified the ancestral arbitration rules. Which brings me to the next argument and main argument here today, that such exclusion of appointing authority mechanism, contrary to what claimant might potentially argue here, does not lead the parties to lex arbitri, the Nubian arbitration law, but rather this tribunal under the ancestral arbitration rules has the authority to decide on Mr. Prasad's challenge without his participation. And we have two reasons for that. First, lex arbitri applies only when the matter is not settled in the ancestral arbitration rules themselves. And in the present case, Article 13 of the ancestral arbitration rules still applies. We have only excluded one subsection of it, and thereby the parties created a special tailor-made regime for themselves under the ancestral rules. Second, as clarified by the ancestral itself in 2016, such tailor-made provisions, I quote, prevail over the default rules of arbitration law since they better correspond to the objectives of the parties, end of quote. Therefore, in the present case, in line with Article 17 of the ancestral arbitration rules, this tribunal has discretionary power to resolve such unregulated matters of procedure, like in the present case, who should decide on Mr. Prasad's challenge.
What is this tribunal to do if we have a withdrawal or a recusal and the remaining two arbitrators disagree on the issue? Do you have a plan B for us?
Of course, Mr. Arbitrator. In line with Article 33 of the ancestral arbitration rules, this is the presiding arbitrator who will resolve a potential deadlock when there is no majority to the decision. And members of the tribunal, therefore, the parties, this tribunal has authority to decide on who should participate in Mr. Prasad's challenge, and this should be done without Mr. Prasad's participation. Since, while exercising its discretion, this tribunal has to observe the principles of fair and equitable process. In turn, it will not be fair to leave Mr. Prasad while deciding on his own challenge. And by this very principle, the drafters were guided, the drafters of the ancestral arbitration rules, and they wanted to prevent the challenged arbitrator from participating in his own challenge. And that is exactly the reason why they created an external body, the appointing authority. However, when there is no agreement between the parties as to the appointing authority mechanism, according to the drafters, I quote, the proper procedure would be to seek a ruling from the other members of the tribunal, end of quote. In other words, the appointing authority mechanism can be derogated, and the drafters analyzed what would happen with the challenge procedure in the absence of appointing authority, and they concluded that the two members of the tribunal without the challenge arbitrator have to decide. To conclude on the first issue, Mr. Prasad's challenge has to be decided by this arbitral tribunal without his participation. Now, turning to our second submission, there are circumstances creating justifiable doubts as to Mr. Prasad's independence and impartiality, and therefore he has to be removed. First of all, in line with Article 12 of the Ancestral Arbitration Rules, the standard for challenges is justifiable doubts. However, as the Ancestral Arbitration Rules themselves do not further elaborate on this standard, we ask this tribunal to apply the IBA guidelines on conflicts of interest as reflecting best practices and describing the content of the justifiable doubt standard. And under this instrument, we raise three main grounds for challenging Mr. Prasad reflected in orange list. First, the current business relationship existing between claimant's third-party funder and claimant's appointee arbitrator, Mr. Prasad. And second, Mr. Prasad's previous involvements in cases financed by claimant's funder. And finally, this ground seen in conjunction create justifiable doubts. Now I will address these grounds in turn. First of all, Mr. Prasad's law firm has a client financed by claimant's third-party funder. On that case, the law firm has already charged $1.8 million, and that case is not finished yet. They still have the enforceability stage to go. And we understand that certainly $1.5 million were charged before Mr. Prasad joined the firm. However, being an equity partner, he has a share in these amounts. But apart from this, members of the tribunal, imagine you're a new equity partner in a law firm. When you come in a new firm, people expect you to bring new business with you. They don't want you to scare the existing business away, which means that in the present case, if Mr. Prasad decides adversely to the claimant, he will put at risk the funding relationship existing between his law firm and the funder, and he will put at risk that client's presence in their law firm. This creates justifiable doubts.
Counsel, I was wondering, how should we see the different entities that Fund sets up for each funding? Because I take it that it was not the same entity that is funding the client in this procedure that was funding the client in the procedure you're referring to.
Mr. Arbitrator, according to Procedural Order Number 3, Fund LP does not have any cases where it funds them directly, so it is usual practice for it to create a subsidiary, which means that at least these subsidiaries have to be equated with the funder itself. And moreover, in the present case, we have evidence that it is Fund LP who brings the business, and the negotiations start first with Fund LP and then with the subsidiary. Like it was in the present case, according to paragraph 5 of Procedural Order Number 2. Therefore, this creates justifiable doubts. As to the second ground...
Excuse me, if I may. As I recall, Mr. Prasad made a first disclosure prior to the funding feature having emerged. And that disclosure, correct me if I'm wrong, concerned whether we had the same parties represented by the same firm. Now, as I recall, there was no objection to that disclosure. And so I would like to know whether you think, as I think there might be, some inconsistency between you're not objecting to that, but you're objecting to a partner representing a party funded by the same funder. That's a rather complicated question, but it's based on the disclosures that were made. Is my question clear?
Yes, Mr. Arbitrator, you refer to the first declaration of independence and impartiality of Mr. Prasad, right?
Yes, I do.
First of all, Mr. Prasad disclosed the current cases in his previous law firm, Prasad and Partners. But the firm we are contesting here is the new one, the merged one, Prasad and Slow Food.
Does that make a difference?
Yes, because there is no advance waiver accepted neither under IBA guidelines nor ancestral arbitration rules, because there is no room for imputed knowledge. And at that time, respondent did not know that such a change would take place.
Thank you.
So, members of the tribunal, I see that my time has expired. May I please wrap up?
Yes, please go ahead.
Members of the tribunal, Mr. Prasad was also previously involved in 2 cases financed by claimant's funder, which were within 5 biggest arbitrations of Mr. Prasad within the last 3 years. This also is another ground that creates justifiable doubts, but in any way, if not on their own, still seen in conjunction, these circumstances create justifiable doubts since they further reinforce each other. If you have no further questions, this concludes.
I'll have another one. I think we're generous on the time. Actually, just 2 things on these prior appointments. I think we could give you some more time to elaborate on this, but then I'm having the question, wasn't one of these prior appointments actually taking place after the funder came in? And the second one, should we take an isolated look, or should we look at it cumulatively? And if so, do you have anything to help us, guide us, which way we should take?
Mr. Arbitrator, we are not relying on appointments, not repeat appointments. We only want to show that there is financial dependency on the part of Mr. Prasad on that funder, because these sums of money amount to 20% of Mr. Prasad's arbitrator fees. If we focus on Mr. Prasad as professional arbitrator, we see that 1/5 of his arbitrator business comes from one source, claimant's funder. This creates justifiable doubts, and therefore we ask this tribunal to remove Mr. Prasad. Thank you.
So excuse me, so I understand, I want to be sure, that you're not concerned particularly about the first disclosure that was made. And is that because the number of prior appointments was unimpressive or consistent with the orange list? But what is your reason for being untroubled by that? Not that I'm inviting you to be troubled, but why are you untroubled?
First of all, when we agreed on Mr. Prasad's appointment, we saw that there were 2 prior involvements. But after that, the circumstances revealed that this number doubled. And now we have 4 previous involvements of Mr. Prasad connected to claimant. And that is why we now see circumstances creating justifiable doubts to Mr. Prasad's independence. Thank you.
Thank you very much, Ms. Goulian. We'll hear from the claimant.
Thank you, members of the tribunal. As I've said, my name is Barnaby Lowe. I'm representing the claimant, and I will be speaking on the procedural issues, which, in short, we regard as nothing more than an attempt by the respondent to delay paying our client for goods which the respondent ordered, the respondent took delivery of, the respondent disposed of, but for which the respondent has not yet paid. We have no doubts, nor should the tribunal, that Mr. Prasad is a man of integrity. In the course of my submissions, I shall mirror the structure adopted by opposing counsel, and so I shall be making 2 submissions. Firstly, that the tribunal should not decide on the challenge to Mr. Prasad, but if the tribunal does decide to hear the challenge, Mr. Prasad should participate on the tribunal. Secondly, on the merits of the challenge, Mr. Prasad should not be removed because there are no justifiable doubts as to his independence and impartiality. On to my first submission, my first point is that the tribunal should not decide the challenge to Mr. Prasad. Contrary to opposing counsel's submissions, the parties have not excluded Article 13.4 of the UNCITRAL arbitration rules. Therefore, a decision should be sought by an appointing authority rather than the tribunal. I'd ask the tribunal to turn to page 12 of the record. This is the parties' contract. It contains clause 20, which opposing counsel has relied on. Opposing counsel pointed out that this is very similar to the model clause contained in the annex of the UNCITRAL arbitration rules, but with two amendments, one of which is the crucial phrase, without the involvement of arbitral institutions. opposing counsel relied on an Article 8.1 of the CISG interpretation of this exclusion of institutional involvement to conclude that Article 13.4 of the Trial Arbitration Rules has been excluded. We would reject such an interpretation. To show this, I'd like the tribunal to turn to page 39 of the record. As I say, opposing counsel relied on the parties' intentions behind this clause and relied on a witness statement of one of opposing counsel's clients. This is the notice of challenge of Mr. Prasad from the respondent. In paragraph 8, about 5 lines down, the respondent explains the reason behind the exclusion found in clause 20. And the reason is because of concerns the respondent had that information would not be kept confidential by any institution. This tells us 2 things. Firstly, that the exclusion in clause 20 was designed to prevent institutional involvement. And secondly, the reason for that is because of concerns by the respondent that institutions would not keep information confidential. This does not lead to the conclusion that Article 13.4 of the Trial Arbitration Rules has been excluded, because under Article 6.1 of the Trial Arbitration Rules, an appointing authority can be a natural person, not an institution, and not under an Article 8.1 interpretation, triggering the parties' concerns about confidentiality. Opposing counsel made 2 submissions why agreement on a natural person is not the right course for this tribunal to take. The first was that up to this point, the parties have not yet had such an agreement. The reason for this is because in the notice of challenge of Mr. Prasad, the respondent challenged application of Article 13.4 of the Trial Arbitration Rules, and therefore it was impossible until the tribunal made a decision on the application of that provision for negotiations under that provision to take place. The second point opposing counsel made was that it was unlikely the parties would reach an agreement. We submit that this is not the case. Firstly, our client wants its money back, it's amenable to agreement, and secondly, and more tellingly, there is precedent for the parties to agree on the choice of a natural person. The parties have already agreed on the appointment of Ms. Ducasse as a potential replacement for Mr. Prasad if he is removed. Opposing counsel relied on the fact that in Article 6.2 of the Trial Arbitration Rules, if the parties couldn't reach an agreement, one of the parties could go to the Secretary-General of the Permanent Court of Arbitration, and that would trigger the respondent's confidentiality concerns because the PCA would have access to sensitive information. We would reject that submission for a number of reasons. We submit that it is possible to go to the PCA without triggering those confidentiality concerns. After all, the Secretary-General has a relatively minor role. His role is to designate the appointing authority. He does not act as the appointing authority. Furthermore, under Article 6.5 of the Trial Arbitration Rules, the parties are permitted to present information to the PCA in any manner they consider appropriate. How is this exercised in practice? We know from the 2006 report of the PCA Secretary-General that the factors taken into account by the PCA when choosing which appointing authority to designate, that the factors relied upon are relatively innocuous. They include the comments of the parties, nationalities of the parties, language, seat of arbitration, etc.
Excuse me, Mr. Lowe, should we not have some concern about the appointing authorities' access to the information? The fact that the Secretary-General of the PCA can make a designation without acquiring information about the case does not seem to me to mean that the appointing authority who is designated would not.
We submit, I'd make 2 points. Firstly, that the appointing authority, we would submit, should be a natural person, and as I've explained, having a natural person involved does not trigger the respondent's concerns about confidentiality. And as I've just said, the PCA Secretary-General takes into account the comments of the parties when choosing which appointing authority to designate. It would be possible, therefore, for the parties to say, we would prefer a natural person as appointing authority.
If we were to leave aside for any number of reasons, the natural person element in your argumentation, do you concede, as you appear impliedly to do, that the use of the term involvement in the dispute resolution clause encompasses the issue at stake here at this moment. Involvement.
It does. That clause is triggered. However, under an Article 8.1 of the CISG approach, contractual provisions have to be interpreted, as opposing counsel said, with reference to party intention. And I've already explained that the party's intention behind this clause was to prevent breaches of confidentiality. And my submission is that even in the unlikely event that the parties couldn't reach an agreement and had to go to the Secretary General of the PCA, it would be possible to do so without triggering those confidentiality concerns. As saying, the report of the PCA Secretary General says that the information required is fairly innocuous, and furthermore, that same report provides that it is possible for the parties to anonymise information sent to the PCA. To move on to the second part of my first submission, if the tribunal does decide to hear this challenge, Mr. Prasad should sit on the tribunal. In procedural matters, the applicable law is the lex arbitri, which in this case is the UNCITRAL model law. The seat is Danubia, which has a verbatim adoption of the UNCITRAL model law. Article 13.2 of that model law provides that a decision on a challenge should be made by an arbitral tribunal. Does that include the challenged arbitrator? In interpreting that provision, we would have regard to the travaux préparatoires of the model law. In that préparatoire, the decision was made by the UNCITRAL working group that there was a general agreement regarding Article 13.2 that, and I'm quoting, the decision is entrusted to all members of the tribunal, including the challenged arbitrator. This decision was made following a concern raised by a representative of Germany about the meaning of Article 13.2, and the working group decided that it was more beneficial to have the challenged arbitrator on the panel rather than have a truncated tribunal.
Thank you. I was just wondering, I take the respondent's position to be that it's not Article 13 of the model law we should apply, but actually the UNCITRAL rules, namely 13 and 17 of the UNCITRAL rules. So can you just help me how I should now get to the lex arbitri, or what we should do?
We would submit that in this situation, a procedural challenge, the appropriate law is the lex arbitri. However, even if the tribunal weren't to agree with me on that point and were to apply the UNCITRAL arbitration rules, we would submit that that does not mean that Mr. Prasad should be excluded. I'd refer the tribunal back to page 12 of the record. Clause 20, subsection A of the parties' agreement provides that the tribunal must be composed of 3 arbitrators, 2 each appointed by the parties and 1 presiding arbitrator. If Mr. Prasad is excluded, it would mean that any award ultimately rendered by this tribunal would be liable for challenge at the enforcement stage under Article 5, subsection D of the New York Convention 1958, because the parties...
That's a different issue, isn't it? The fact that Mr. Prasad would be sitting in judgment of his own, the challenge to his independence and impartiality is one thing, and the question whether if he were to stay, then he would be making a decision on the merits of the dispute. That's a different issue, and because if he's challenged and successfully challenged, then he would be replaced, so we would have a tribunal of 3 members.
That's correct, Madam Arbitrator, but what I'm submitting is that if he's not permitted to hear the challenge and is excluded from the tribunal, there would only be 2 arbitrators, and this would still breach the parties' agreement, and that would still lead to a potential challenge at the enforcement stage.
How do you address the respondent's point on the fact that Mr. Prasad would be judging, would be sitting as a judge in his own case? How do you address that?
In that case, the parties are relying on general principles under the arbitration rules and under the model law. However, what is also important when interpreting the rules and the model law, as reflected, for example, in Article 2A, subsection 1 of the model law, is that regard be had for the need for uniformity when applying these rules. And we would submit that the best way of ensuring uniformity is to have regard for 2 things. Firstly, things like the travaux préparatoires, to which I've already referred the tribunal, which applies to the model law, and secondly, to state practice. A number of states have challenge procedures which include the challenged arbitrator. To give 2 examples, that is true of Hong Kong, that is true of Germany.
Mr. Lowe, I'd like to go back to the chair's question because I'm still not quite satisfied. isn't there a significant difference between having a truncated panel on the merits of a dispute, and I think that was the gist of the chair's question, and having a truncated panel on the disqualification question, where there is in fact a good reason for exclusion. I quite agree that if a party to the proceeding is unable to have a party-appointed member of the panel, that would present a very serious problem at the enforcement or annulment stage. But we're not talking about that. We're talking about the disqualification issue. And do you believe that the importance of having a 3 members present and voting is of the same importance on a disqualification issue as on a merits issue?
We would submit that it is, yes. Article 5, subsection D of the New York Convention 1958 provides that an award can be challenged if, during the course of an arbitration, including on procedural decisions, the parties' agreement on the composition of the tribunal is not respected. Therefore, even if Mr. Prasad were excluded only at the disqualification hearing, that would trigger a potential challenge under 5D. Furthermore, this is reflected by the parties' intentions. On pages 8 and pages 15 of the record, when talking about the arbitration clause, the parties make it clear in relation to that clause that it relates to the composition of the tribunal.
Are you quite sure that our eventual award would be jeopardized if the only element of exclusion were at the disqualification stage?
We submit that that would be the case, yes.
Thank you. I have one other question. I have one other question for you, and that is your choice, your ability to choose an arbitrator does not necessarily mean your ability to choose the arbitrator of your first choice. So why couldn't you content yourself with the appointment of an arbitrator that raised no problems?
In that situation, if the tribunal were to direct us to do that, we would be happy doing that.
Thank you.
Thank you. I've already overrun. Would it be possible for me to address the 2 circumstances relied upon by opposing counsels? Thank you. Opposing counsel relied on 2 circumstances to submit that there are no justifiable doubts as to Mr. Prasad's independence and impartiality. The first was the connection between an arbitrator at Mr. Prasad's law firm in an arbitration funded by fine funds. This cannot give rise to justifiable doubts for 2 reasons. The first, if the tribunal would turn to page 50 of the record, this is the second procedural order, we're told that fine funds only has a 40% stake in funding 8, which is the subsidiary funding that agreement. The logic of opposing counsel's submission was that Mr. Prasad, if he were to render an award unfavourable to fine funds, might put at risk that funding relationship. Whether or not a minority shareholder actually has that kind of power to choke off funding to an arbitration, we submit is unlikely. But in any case, opposing counsel talked about the existence of a significant commercial relationship. The tribunal would look at paragraph 6 of the second procedural order. We're told that the amount of money expected to be charged is a further $300,000. The $1.5 million referred to by opposing counsel has already been paid and has been paid to a separate law firm, Slow Food. So the amount of money we're dealing with is the $300,000 expected to be paid. Paragraph 6 also informs us that that figure, $300,000, represented 1% of the turnover of the law firm Slow Food. Therefore, we could expect that figure to represent less than 1% of the turnover of the bigger firm, Prasad and Slow Food. And furthermore, as I've already said, Fine Funds has a minority shareholding in the funding subsidiary. Therefore,
aren't we so much really concerned about direct influence and direct chain of command, so to speak, or rather what Mr. Prasad might feel?
That is correct. Opposing counsel was submitting that Mr. Prasad might feel like he was in a position whereby he couldn't jeopardize a financial relationship with Fine Funds. I'm making 2 points. Firstly, it's unlikely that any award he rendered would lead to Fine Funds having the power to do anything about that award, even if it was unfavourable to them. And And the second is that the figure of money we're talking about here is a fraction of less than 1% of the turnover of his law firm. The suggestion that Mr. Prasad would be willing to sway his vote one way or the other in order to secure a fraction of less than 1% of his turnover is an unreasonable one. I'm aware I haven't had time to address the second circumstance opposing counsel relied upon, but since I'm so over time, 1 minute. In that case, opposing counsel submitted that the previous appointments by fine funds gave rise to justifiable doubts. These cannot give rise to justifiable doubts for one reason. Fine funds did not appoint Mr. Prasad. Paragraph 4 of the second procedural order tells us that fine funds exercises little influence over the appointment of arbitrators. How does this work in practice? We know on the facts, as Mr. Arbitrator pointed out, in one of the two previous arbitrations, fine funds only got involved after Mr. Prasad's appointment. We know that in this arbitration, Mr. Prasad wasn't aware of fine funds involvement until the 7th of September 2017. And to make a more general point, any reasonable person would know that third-party funders are wary of exercising a controlling influence over arbitration for fear of attracting regulatory scrutiny. This was a point made by the third-party funder Omni Bridgeway at a roundtable event hosted by the Global Arbitration Review in 2010. To conclude, we have 3 points to make. Firstly, the tribunal should not decide on the challenge to Mr. Prasad. Secondly, if it does so, Mr. Prasad should participate on the tribunal. And thirdly, on the merits of the challenge, Mr. Prasad should not be removed because there are no justifiable doubts as to his independence and impartiality. Thank you.
Thank you very much.
Members of the tribunal, respondent will raise 3 grounds on rebuttal. First, as regards the exclusion of appointing authority mechanism, the opposing counsel proposed some arrangements to ensure the confidentiality of our case while having recourse to the Secretary General of the Permanent Court of Arbitration. However, we are not suggesting that the information will be for sure leaked. This is about risk. The Secretary General may or may not rely on his stuff. This is something unclear and still to be ascertained. But in the present case, given the parties' this desperate confidentiality concern, they would have never agreed on such a broad and shapeless mechanism. And for this reason, we ask this tribunal, in which the parties have already vested their mutual trust, to decide on the challenge. As to the second point, the opposing counsel relied on model law. However, we are not applying model law. We have to ask this tribunal to honor our parties' intentions to have their arbitration under the UNCITRAL arbitration rules. And this will be their agreement, and therefore there will be no grounds to challenge the award under the New York Convention because the composition will be in line with parties' agreement. And finally, as regards the circumstances which give rise to justifiable doubts, we are not relying on significant commercial relationships. The standard we apply is standard number 3.2.1, which simply states that there are justifiable doubts when the arbitrator's law firm is currently rendering services to one of the parties without creating a significant commercial relationship. We don't have to show a significant commercial relationship here.
You have to show the lack of independence.
Yes.
So where does lack of independence start?
In our submission, there had already started that lack of independence when Mr. Prasad's law firm has engaged that client, when it continues to render services to claimant's funder and to their client, and when it accepts fees from claimant's funder. Therefore, it suggests that Mr. Prasad is financially and professionally dependent on claimant's funder. Thank you, members of the tribunal.
Thank you. Mr. Willem?
Thank you, members of the tribunal. Opposing counsel made 3 points of rebuttal, and I shall deal with each of those. Firstly, opposing counsel said that an appointing authority should be excluded because the parties wanted to exclude the risk of breaches of confidentiality. We would submit that the risk of confidentiality breaches is minimal to the point of non-existent if one of the abilities of the parties is to anonymize information it sends to the Secretary General of the Permanent Court of Arbitration. Secondly, opposing counsel said that we had to rely on the UNCITRAL arbitration rules rather than the UNCITRAL model law, because the parties agreed to application of the UNCITRAL arbitration rules. That is true. However, the parties also agreed on 3 arbitrators, and that would not be the case if Mr. Prasad were excluded from the decision on the challenge. And thirdly, on the relationship between fine funds, I simply point out the following. There was no significant commercial relationship between Mr. Prasad's law firm and fine funds. There were no powers of appointment by which fine funds could influence Mr. Prasad, nor was there any economic relationship of dependence, given that Mr. Prasad derived such a small amount of his total income, between 5 and 7.5% of his total income, from arbitrations in which fine funds had an interest. Thank you.
Thank you. So now we move on to the merits, and I think it's the claimant, Mr. Cooper. Thank you very much.
Good afternoon, members of the tribunal. My name is Ian Cooper, and further to the introduction, I shall be addressing the third and fourth issues under the first procedural order. We're here today because respondent refuses to pay for 600,000 cakes which respondent argues were inconsistent with its principles of sustainability, yet was nevertheless willing to distribute to its customers as part of a marketing campaign. And my client seeks payment for these cakes as it is rightly entitled to do so. My client has itself been a victim of fraud. The party's contractual recipe, namely a contract governed by my client's standard conditions, imposes an obligation of best efforts, and my client has therefore delivered ingredients conforming to this recipe. Respondent's attempt to now argue that its standard conditions govern this contract is half-baked and should not be accepted. I make 2 submissions. First, that it is my client's standard conditions that govern this contract. And second, even if respondent's standard conditions are applicable, my client has delivered goods conforming to this contract.
Mr. Cooper, I have a preliminary question. Before I turn to the question of whose conditions govern, there's a premise in your remarks that your conditions require best efforts only. Could you point me to the language that demonstrates that the expectations upon which the parties agreed were best efforts only?
Of course, Mr. Arbitrator. Could I direct you to the second procedural order, paragraph 29, which is to be found on page 53. On the third line, I read, Delicatessen Whole Foods will always use its best efforts to guarantee that the goods sold match the highest standards in line with its business code of conduct and supplier code of conduct. If that satisfies Mr. Arbitrator, might I continue?
Yes.
Thank you very much. So, to determine which party's standard conditions govern this contract, one must first establish under what legal framework are we operating, and it is undisputed between the parties that it is the CISG which governs this contract and its interpretation. Reference can therefore be had to CISG case law, and we submit specifically the CISG Advisory Council Opinion number 13. This was published in 2013 on the very question before the tribunal today, namely the inclusion of standard terms and conditions. And it is our submission that my client, in satisfying the 4 requirements laid out therein, has successfully incorporated its standard conditions, and this was consistent with party conduct. The CISG Advisory Council opinion, as I explained, imposes 4 requirements. The first one, found in paragraph 1.6, and I will quote, is that the offeror, here claimant, must clearly communicate to the offeree, which is here respondent, that it wants the agreement to be subject to its standard terms. I direct the tribunal to page 16 of the bundle.
You know, Mr. Cooper, before we go there, ultimately Article 35 of the CISG is central. Would you agree?
Article 35?
Yes.
The conformity of goods
Yes.
is a very important consideration under the fourth issue of the first procedural order, namely the conformity of goods. However, when determining which party standard conditions govern the contract, we must first consider the party intention and interpret contractual correspondence.
I understand that, but I simply want to call your attention to and seek your response to the fact that Article 35 says that the seller must deliver goods which are of the quantity, quality, and description required by the contract. Now, how do you square that with a best effort standard? This is a reference to, in fact, it states, as I see it, an unqualified obligation to deliver goods, among other things, of the quality required by the contract. Did the contract not require sustainably produced cakes?
We acknowledge that there is an Article 35(1) obligation contained within the contract. However, it is our submission that when determining whether the goods are of the quantity, quality, and description, the important question is what standard are we to impose when establishing whether the description has been met? Is it a strict standard of result, or is it an obligation of best effort?
But we have here a description, a reference to a description of the goods. And the goods are described as having to have a certain quality. Is that quality satisfied in the present case?
We would submit that the quality has been satisfied, and that is because the description of the goods, which is found in the general conditions of contract, states that the goods must conform with all obligations arising from this contract. Therefore, one must determine whether the obligations arising under the contract have been satisfied, and when doing so, we must address the question, which we will turn to under my second submission, namely what is the standard of the obligation.
Thank you.
Exactly, thank you. I think in discussing that, I think we have to speak about the one topic you mentioned, namely the clear communication. And I think you had referenced this to page 16.
That is correct.
So let me just ask the question up front. We all know your client referenced in the footer the claimant standard conditions. And it is also known that they also attached the tender documents, let's call them the respondent's general conditions to be a bit precise. So what are we supposed to make of this in terms of the requirement for clear communication?
It is our submission that my client has clearly expressed its intention to derogate from the tender documents to the extent that my client's standard conditions are applicable. Mr. Arbitrator has referenced the footer found on page 16. If the tribunal turns back one page to page 50, we find the letter which was attached to the sales offer. Reading from the final paragraph, the final sentence of Mr. Tsai states, if you have any further questions, in particular concerning our applicable sustainability strategy, please do not hesitate to contact me. It is our submission that in inviting further questions to Mr. Tsai's applicable sustainability strategy, Mr. Tsai is demonstrating his intention to incorporate my client's standard conditions, which will be reflective of the sustainability strategy. Moreover, we know from the second procedural order that the footer, which is found on the bottom of page 16, was also included in approximately 31 invoices which were sent from my client to respondent. Reference can be had to such post-contractual conduct under Article 8.3 of the CISG when interpreting the contractual provisions.
Just maybe one follow-up, but I think we are getting to the point anyhow. So basically, are you saying, by saying, well, we've made a few choices, there's one concrete choice here, another one here, and in particular, so please, other side, just check all the documents for yourself, where there might be other changes. And in light of the fact that it was a tender situation, where the respondent had made it clear that actually they wanted their standard conditions to apply, wouldn't that have been a bit unfair to require the other party basically to look for any changes made?
We do not believe that it was unfair, as Mr. Tsai did not require Ms. Ming to look for changes. Rather, in the final sentence of the letter, he invited questions on the standard conditions specifically.
But how can you see in that sentence an express derogation? And I'm quoting you. You would expect an express derogation to specifically refer to the code of conduct and say, we do not refer to your code of conduct, instead our code of conduct will apply. We don't see any language such as that. So how do you explain that?
The express derogation we submit is found on page 16. It is the footer which is clear and precise as to Mr. Tsai's intention. The sentence which I've directed the tribunal to on page 15 is to be considered alongside the sales offer.
Did you just say that that your client explicitly invited the respondent to consider the matter of your client's standard conditions in this letter?
It was our submission that Mr. Tsai invited questions on the applicable sustainability strategy, which we submit is to be interpreted as the standard conditions, as they are reflective of the applicable of the standard conditions. Furthermore, we must consider that on the fact Ms. Ming read this footer and directed herself to the website on the basis of the footer and downloaded the codes of conduct, she in fact endorsed them. And this is reflective of the third requirement under the Advisory Council opinion. And they stated that the incorporation of standard conditions shall be successful unless the offeree clearly indicates that it does not agree to such incorporation. And in this letter on page 17, Ms. Ming has endorsed the codes of conduct. We see no clear indication from Ms. Ming that she rejects the inclusion of the codes of conduct.
Mr. Cooper, it seems to me that you're essentially inviting us to disregard the really seems to be a very vast difference in the degree of emphasis that the parties gave to the standard to be used. I won't use our time, which is precious, to go through all the indications we have of the and direct and express indications we have of the importance to your opponent of the content of its conditions being adhered to. And it sounds like we, in your view, we oughtn't take into consideration the degree to which your and their commitments were articulated. Yours is articulated through a footer with a reference to a website, and theirs is reflected in any number of communications, starting with the invitation to tender and others. We want to take a contextual, somewhat contextual view of things.
And we would direct the tribunal to do so. And when considering the volume of correspondence between the parties, I might remind the tribunal that Mr. Tsai incorporated this same footer on every invoice which was sent to respondent for approximately 3 years. When the tribunal is looking for direct, clear expressions of intention, it is our submission that these provide the best example. To conclude I'm very conscious of time. To conclude my first submission, it is that it was consistent with both parties' intentions to incorporate my client's standard conditions. And in turning to my second submission, might I request a further 2 minutes?
Yes.
In order to lay out my submission and then to conclude. To provide the wider context under the second submission, it is our case that my client has delivered conforming goods pursuant to this contract. The obligation was one of best efforts, and my client satisfied this obligation on the facts. And I'd like to remind the tribunal of 2 very important considerations. And first, that respondent is requesting the tribunal derive a commercially impracticable obligation, an obligation of strict result, in the absence of any express or clear wording to such effect, and we would request that the tribunal not do so. And second, it is inconsistent on the part of respondents to argue, on the one hand, that the cakes were not compliant with its principles of sustainability, and yet, on the other hand, as I outlined in my introduction, to use these cakes, to distribute these cakes to its customers as part of a marketing campaign. Respondent states in the contractual correspondence it wishes to become a global compact league company, and yet it alleges that the use of such cakes would endanger its reputation, but uses them with its customers. Turning now to my submissions on this point, it is our submission that the obligation was one of best efforts. To demonstrate that this is the case, I direct the tribunal to page 14 of the bundle.
Mr. Cooper, very quickly, if the parties wanted to, or I should say, if respondent wanted to communicate that it was strict result obligation, what more would you have expected to appear than the word ensure or to make sure? No, I'm thinking of the word insurance when I hear the word ensure. Insurance suggests to me, more likely than not, result.
My submissions on that point are in two parts. First, if Mr. Arbitrator, in using the word ensure and make sure, is referring to sections C and E of the Code of Conduct, then in answering that part, I will direct the tribunal to section F. However, before I do so, I would also like to highlight that the use of such language is not, as I explained, is not consistent. And to demonstrate that this is the case, I would briefly like to direct the tribunal to page 41 of the bundle. This is the witness statement of Miss Annabelle Ming, in which she is describing the discussions that took place in the Kachina Food Fair. And reading from the third paragraph, Miss Ming describes Mr. Tsai's pride that he took in the fact that my client could, and I quote, largely guarantee compliance with the code. Now, when we're interpreting language and contractual documents, it is our submission that the language largely guarantee is not to be regarded as being synonymous with a strict obligation of results, rather than an obligation of best efforts. And I would remind the tribunal that it was on the basis of this assessment that Miss Ming chose my client in the tender process, and we submit, therefore endorses an obligation of best efforts. And in answering the first part of Mr. Arbitrator's question, I explained I would direct the tribunal to page 14, section F of the Code of Conduct.
I'm taking my time to wrap up.
Of course. I will answer the question and then lay out our prayer for relief. I will read from the first paragraph of F. It states that in order to ensure and demonstrate compliance with the code, you shall keep record of all relevant documentation and provide to us supporting documentation upon request. Clause F therefore instructs my client as to what is necessary in order to ensure and demonstrate compliance. Documentation must be kept and must be provided upon request. And we know from the second procedural order that such an auditing and documentation process was undertaken in the summer of 2014. And now to lay out my request for relief, which is to be found in paragraph 178 of our memorandum, we request on 5 parts. First, that the arbitral tribunal does not have jurisdiction to decide on the challenge, but if it does so, Mr. Prasad should sit. Second, that Mr. Prasad should not be removed from the tribunal. Third, my client's standard conditions given the contract Fourth, that even if respondent standard conditions are applicable, my client has delivered conforming goods. And fifth, it is respondent that must bear the legal costs for this arbitration. And that concludes my submissions.
Thank you very much. Mr. Costa?
Madam Presiding Arbitrator, members of this tribunal, my name is Vladimir Kostov, as previously introduced, and in the following 14 minutes I will present the respondent's position on the merits of the present dispute, addressing the issues raised by claimant in the same order. I will therefore first argue that respondents and not claimant's standard conditions govern the contract, and that second, under respondent's standard conditions, claimant was under a duty of result and not merely best efforts. Coming first to the issue of applicable standard conditions. Here we agree with claimant that the CISG is the appropriate standard, and that case law on the CISG has to be considered. In this regard, in the machinery case, it was stated that in order for standard conditions to be incorporated, the intention to this effect has to be communicated, not just clearly, but this intention has to be apparent. In this regard, this tribunal, pursuant to Article 8, Paragraph 3, needs to consider all circumstances of the case and understand whether the parties indeed had an intention to incorporate claimant's standard conditions and whether this intention was communicated clearly. This is even more so that the sales offer itself, as previously examined by this tribunal, is incoherent. On the one hand, we have a reference to standard conditions at the footer of this page, but on the other hand, claimant attached a full set of respondent standard documents, including the standard condition. It did not stop there. In fact, it also filled in the blanks, the party names, thus indicating its intention to be bound by the tender documents. Considering a similar situation, the Golden Valley case of the United States decided that even in the absence of an incorporation clause, the mere physical communication of standard conditions was sufficient for their incorporation. However, we understand here that this tribunal cannot simply disregard the footer reference at claimant's standard conditions as well, and therefore we invite this tribunal to put the sales offer in the context of the contract conclusion to understand respondents' understanding of the situation and of claimant's intention. This is precisely what was done by the United States courts in the Roser Tex case, which analyzed the whole situation and concluded that the parties never discussed the application of the seller's standard conditions, and that the contents of these standard conditions did not match the parties' previously expressed agreements. And the situation is similar in the present case. The parties never discussed the application of claimant's standard conditions, but as previously underlined by Mr. Arbitrator, the parties numerously discussed, and the most prominent example is page 8 of the record, that it is very, if I can invite this tribunal at this time to page 8. Here on page 8 of the record, members of this tribunal, paragraph 3 of the main body of the text, line 4. Respondent, in its cover letter to the tendering documentation, made clear to claimant that, and I quote, "It is very important for us that we can be sure that also your suppliers adhere to respondent's code of conduct for suppliers." Upon receiving this document, upon this clear manifestation of respondent's intention, what did claimant do? Members of this tribunal, I invite this tribunal to follow me at page 28 of the record at this time. On page 28 is located claimant's letter of acknowledgement, where in paragraph 3, claimant not only failed to express its disagreement with our emphasis on our standard conditions, but in fact explicitly promised to tender in accordance with the specified requirements. Now, members of this tribunal, we do not argue here that this is a legally binding promise of claimant. Indeed, claimant could, in fact, propose different conditions in its sales offer as the offeror. At the same time, in our submission, this letter needs to be considered by this tribunal, among other factors, as further raising the level of clarity that was required from claimant in order to clearly enunciate its intention to replace half of the contract, the standard conditions.
Mr. Kostov, I have a question regarding C5. If you can take it, please. It's a letter from Ms. Ming to the claimant, referring to such commitment, I quote, is well evidenced in your impressive code of conduct. So there's an express reference here by the respondent to the claimant's code of conduct. So would that be, should we understand this as the fact that the respondent has, therefore, accepted that the applicable code of conduct is the claimant's, or do you have another position on this?
Members of this tribunal, the appropriate standard under the CISG is not just awareness of the contents of standard conditions, but in fact awareness of the intention to make them legally binding. And the counsel for the opposing party emphasized that on page 15, claimant itself referred to its codes of conduct as the applicable sustainability strategy. And this is in fact what Ms. Annabelle Ming reasonably understood, and I invite this tribunal to page 30 of the record at this time.
Page
30.
30.
Here on page 30 of the record is located claimant's own business code of conduct, which Annabelle Ming indeed read. Under the first heading, the confidential information, it states that employees of claimant are required to keep company information confidential. Under the second paragraph, employees must never give or receive bribes. And finally, under the last paragraph, under the title of Implementation and Enforcement, it states that the CEO is responsible for ensuring that all employees are informed and educated. Members of this tribunal, this is what it is, a sustainability strategy, an internal document which has no contractual bearing. It applies within claimant itself, and this is what Ms. Annabelle Ming was praising. She was praising how claimant conducts its business internally, but she emphasized that she read it out of curiosity because she never understood, and in fact had no reasonable opportunity to understand, that these documents would be made legally binding in the legal relations of respondent and claimant.
One follow-up question by me. Just, I take it that we are beginning in the interpretation of the declarations of the parties, of course. Just wondering about the point I also raised to the opposing side. There was, after all, a slight reference by the claimant to the respondent in that letter where they said, well, primarily it's two changes, but primarily, of course, means that there may be others. So couldn't we think that your client had reason, maybe, to be wary of other changes being suggested as they were in the footer? And if simply giving them the contract, nevertheless, we don't think that your client maybe had simply taken the risk and didn't care in the interpretation process, of course.
Before you answer that, just a couple to that question. We have a lot of attention being given to the footer, but very little attention, if I can direct your attention to page 15, to what appears to be the transmittal letter of the offer. And in the final paragraph, the second sentence says, you can be assured that we will do everything possible to guarantee. Now that is a statement not of a guarantee. That is a statement of a willingness to do everything possible to guarantee. Did that not also strike your client, I should say?
Members of this tribunal, unless you object, I will answer the questions in turn, and coming first to Mr. Arbitrator's question. Indeed, the accompanying letter located on page 15 used the words primarily, which claimant may use to advance its argument, stating that our client should have been triggered by this. At the same time, it uses it in the context of very explicit wording, minor amendments, and we do not doubt claimant's good faith here that having received respondent's letter where respondent emphasized how important it is for respondent that its standard conditions govern the contract, certainly claimant would not refer to such replacement as a minor amendment and would elaborate on them in the following paragraph. But members of this tribunal, another issue that needs to be considered and which actually would mislead a reasonable person in respondent's shoes is paragraph 4 of the main body of the text. Here, on page 15, here claimant states, thank you for your information concerning the arbitration clause contained in the invitation to participate in the tender process. We can very well live with the clause as it is. We admit that this phrase may be used by claimant as a cardinal. Claimant may allege that this is an exception from the application of its standard conditions. At the same time, the wording here is clear. Claimant does not state that this is the only provision that they accept, thus leading our client to a reasonable understanding that by relying on respondent's standard conditions where the arbitration clause is located, they accept the standard conditions as a whole. And this is consistent with the reasoning of the German Supreme Court in the case of Powder and Milk, where it was stated that standard conditions need to be viewed as a whole. Therefore, claimant could not simply pick and choose applicable standard provisions within different sets of standard conditions. Now turning to the second question by Mr. Arbitrator. In this regard, definitely we see the wording, you do everything possible to guarantee, but context here is crucial. The first sentence in that paragraph states, we hope that you find our offer attractive despite the necessary minor amendments. Now, members of this tribunal, imagine if you were hiring a construction contractor to build your house. The construction contractor would come to you with an offer, stating, I hope you find my offer attractive, and I will do everything possible to guarantee that the materials I will use will match the highest standards. Will you understand this reasonably as a limitation of liability, or in fact merely as a factual commitment to do everything possible, in fact, to guarantee compliance? And this, members of this tribunal, brings me to my second issue here today. Two arguments have been put forward by the opposing counsel in order to justify its contention that a mere best efforts standard has to be applied. The first argument is similar to the question raised by Mr. Arbitrator, the fact that Annabelle Ming in her witness statement used the words largely guarantee and not guarantee. The situation here is similar. This was done in the context of a commercial discussion, and of course physically one can never guarantee that a contractual breach will not occur, but one can accept the risk. And in our submission, this is exactly what happened. I invite this tribunal to page 14 of the record to consider the applicable code of conduct and to consider claimant's argument that there is no express wording on what obligation this is. Here on clause E, it is stated that claimant was obliged, and I quote, under all circumstances procure goods and services in a responsible manner. And this is defined, for instance, particularly in the second bullet point, where it is stated that claimant was to make sure that its suppliers comply with the standards agreed upon, such as the prevention of bribery in clause D. In our submission, it is not necessary under the CISG to elaborate further. In fact, the default rule under the CISG is strict liability. As it was examined by members of this tribunal at the beginning of the opposing counsel's presentation, Article 35 of the CISG particularly is clear. It is always an obligation of result. Just like claimant cannot excuse itself from liability by stating that cakes were not physically poisoned, we find it impossible for claimant, if it accepts as it did, that these standards are part of the quality of the cakes themselves, then we find it impossible for claimant to argue that this was a best effort standard. Conformity under the CISG is a matter of result, as pointed out by the Weinbox case, for instance. And this, members of this tribunal, is sound with a policy and economic perspective. But before I elaborate on this point and quickly conclude, I have an additional 1 minute.
Yes, please.
Thank you, members of this tribunal.
You actually have 2 more minutes.
Thank you. Members of this tribunal, as it was stated in the compound fertilizers case, it is important not to break the chain of liability. And if, for instance, now we decide that claimant only uses best efforts, this will essentially mean that respondent is left without a remedy, and claimant will not have a remedy against the final supplier that actually committed these ethical breaches. Therefore, this will be an unsound allocation of risks, which is inconsistent with the default rule under the CISG, which is there for a reason. Claimant is the one closer to the risk. It chose to contract with this supplier. It had contractual means to control this supplier and can now claim damages from this supplier. On the other hand, respondent not only had no ability to prevent these violations as it had no contract with the supplier, but is now left without a remedy.
Well, the claimant does say that they have controlled and they were deceived in that control. So what is your position on that? Because they did not only their best efforts, but they were guaranteed that the products they were receiving were actually performed. So I understand your point on allocation of responsibility, but what do you say on that exact point?
Madam Presiding Arbitrator, indeed we appreciate the efforts put forward by claimant. But here, as a commercial party, as a businessman, it accepted the risk, not merely undertook to do what's possible. And in fact, members of this tribunal, for this reason, we are not trying to punish claimant here. We are merely allocating the risk, and we submit that it is fair for this tribunal choosing on whom to place this risk, on respondent who had no means at all to control it, or on claimant who had a contract with his supplier and can now claim damages. Members of this tribunal, to conclude, I would also like to briefly address the argument of the opposing counsel, again unworthy. In our submission, the parties knew how to derogate from the default rule of the CISG with specificity. On page 12 of the record, clause 21, the confidentiality clause, paragraph 2, second sentence. Sorry, the first sentence. It is stated after the comma that the parties are to exercise best endeavors to procure that such persons under their control keep information confidential. Therefore, the parties were aware of the usual practice to limit liability to best efforts, and we see no reason why this provision has to be implied by this tribunal in the Code of Conduct. Thank you, members of this tribunal, for your attention and time.
Thank you very much. We're limited by time, so we will reduce to a strict 2 minutes rebuttal on each side. Please go ahead.
In rebuttal, I make 4 points. The first is that opposing counsel took the tribunal through a chronology of events. The letter on the 10th of March, on page 8, and then the letter of acknowledgement sent on the 17th of March. However, at that point, the chronology stopped. And as I have directed the tribunal to the letter sent on the 28th of March 2014, this is the letter on page 15, Mr. Tsai therein expressed his intentions to change the terms under the tender process. Therefore, whilst Mr. Tsai signed the letter of acknowledgement, he then expressed changes at a later date. The second submission is that opposing counsel argued that the codes of conduct were deemed to be of no contractual bearing, the codes of conduct found on page 30. However, I've directed the tribunal already to paragraph 29 of the second procedural order, and therein a statement from the general conditions of sale referenced the code of conduct that Ms. Ming refused to read such code. The general conditions of sale was a risk that Ms. Ming undertook. Third, when discussing the use of respondent's arbitration agreement, opposing counsel failed to mention Rule 8 of the Advisory Council opinion, which is that negotiated terms take precedence over standard conditions, and therefore, in light of party discussions, the dispute resolution clause had been elevated. And fourth, respondent argues that it has no remedy. I remind the tribunal again, respondent refuses to pay for cakes, yet is willing to give them away to its customers, thus deriving a commercial benefit. And that concludes my rebuttal.
Thank you very much. Mr. Foster.
Madam Presiding Arbitrator, members of this tribunal, I will address the 4 points raised by the opposing party in turn. First, in relation to, again, the letter of Mr. Tsai on page 15, where he allegedly expressed a clear intention to incorporate claimant's standard conditions. As I have underlined, this letter was misleading, as Mr. Tsai referred to our standard conditions, called them minor amendments, and then only referred to an applicable sustainability strategy, which by its wording does not implicit a contractual document, but an internal regulation. Coming second to the issue of claimant's code of conduct. Indeed, paragraph 29, procedural order 2 states that Delicacy Whole Foods will use best efforts to comply with its own codes of conduct. Now, it is not in dispute that Ms. Ming only read the codes of conduct, and we are here establishing the respondent's, first of all, subjective intention pursuant to Article 8, paragraph 1. But even if we consider that Anna Belming accepted this risk. We submit that since it is claimant's argument that its code of conduct also should apply, this tribunal needs to consider the judgment of the Netherlands courts in the Bernard v. Planten-Hantel case, where it was stated that when the wording of standard conditions is incompatible with the role of the party, for instance in that case, the standard conditions were applicable to situations when the seller was a buyer, such standard conditions have to be disregarded. Here, the standard conditions govern employee relations and relations of claimant with its suppliers, and by the wording do not apply to relations with claimant and its customers.
Your 2 minutes are up, but please wrap up.
Members of this tribunal, finally, the arbitration clause. We do not dispute that the parties could have agreed on it individually, but in that case, claimant should have made it clear in the sales offer, under the specific terms and conditions which are used to deviate from its general conditions, it should have been written arbitration clause as per the tender documents. And finally, the question of the cakes being given away is irrelevant for these proceedings as it relates to the estimation of the price to be paid and mitigation of damages, which is a subject matter of further inquiry of this tribunal. Thank you for your attention.
Thank you very much. This completes the hearing. I will now ask the parties to leave the room for our deliberations. Thank you very much for a wonderful presentation.
Ladies and gentlemen, counsel for both parties and tribunal, I think the round of applause we've just heard demonstrates what an excellent hearing this was. So thank you again for everyone here on the stage. Ladies and gentlemen, that concludes the formal part of the hearing today. And we will shortly be beginning the more festive part, the banquet. But in